Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you would like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates. Let's see here, that way we can respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of elder abuse. Let's see here. My wife is accused of physically mistreating elderly people in a rehabilitation center where she works. Okay, yeah, this would be a violation of Penal Code Section 368, parentheses B, parentheses 1. This is a felony that carries up to 3 years state prison. No, I'm sorry, 4 years state prison. So here's the thing: if you are charged with the care of an adult, if you're charged with the care of an elder adult, elder dependent adult, you cannot cause them psychological anguish, any mental anguish, on purpose, obviously, and you cannot cause them any kind of physical harm. You cannot do this, at least not purposefully. You generally speaking you can't cause somebody purposeful harm anyway, but when it comes to elder abuse, the punishment is far harsher. It doesn't have to be felony behavior. Normal misdemeanor behavior, for instance, a normal battery, but to an elder that you have to care for, would be charged as a felony under 368, parentheses B, parentheses 1. In this situation, it's going to be necessary for a private investigator to go in to obviously interview the people there, the other staff, to see if this person has complained about other staff members. Because if this person is a chronic complainer, it's possible that this is just what he does. Or maybe the other thing that's possible is maybe he was traumatized, maybe he was hurt by somebody else in his past, and maybe because he might have some mental problems now, he may be attributing that harm, he may be attributing this to somebody else, when in fact it was somebody outside of the home, outside of the rehabilitation center, that may have done this. Because you also need to ask yourself, what is he doing in a rehabilitation center? Because he clearly may have some kind of mental problems. We're not talking about we're not necessarily talking about a rest home here. So, and of course, at the end of the day, you know, if the DA still decides to file the charges, well, then your attorney is going to have to cross-examine the staff and cross-examine the alleged victim. Now, if the victim is giving inconsistent statements, that would be a basis to present those inconsistent statements to a jury so that they can decide whether or not those inconsistencies bring forth reasonable doubt. More likely they would. Usually when a victim gives inconsistent statements, that is reasonable doubt, and if there is reasonable doubt regarding the guilt of a defendant, the case should be dismissed. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of a fight in public while being on probation. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.